with that said, I want to now introduce our, excuse me, managing partner of the Tampa office location, Kerstin Henze. Kerstin, take it away.
Hello, thanks, Jeff. As Jeff mentioned, my name is Kerstin Henze. I'm the managing attorney for the West Coast office for K-Bend and Renbound. We are located in Tampa, but we certainly service, many clients across the West Coast. So if you are in need of legal representation, don't hesitate to call. So today we'll be talking about covenant enforceability, and I pulled up my slide here. Let me go to the next page.
Yeah, we could see it. It's looking good.
Yeah. Okay, great. So we're going to be talking about everything concerning covenant enforceability. So as the first slide says, the association is charged with the responsibility of uniformly enforcing the governing documents, covenants, restrictions, rules, and regulations. Failure to do so in a timely manner may result in waiver or forfeiture of enforcement rights. So first of all, let's kind of break down the statement. In order to successfully enforce any covenant, restriction, or any rule, you want to make sure that you have clear, express restrictions and rules, okay? If you have ambiguous or vague covenants in your governing documents, or vague or ambiguous rules, then enforcement will be problematic, and you potentially subject the enforcement action to successful defenses. Okay, so when you amend your governing documents or you amend rules, make sure you work with your legal counsel to ensure that your restrictions and your rules are as clear as can be. One thing I want to talk about, enforceability of rules. So your covenants and restrictions would be set forth in your declaration, whether it's the declaration of covenants for HOAs or declaration of condominium for condominium associations. Rules are not part of your governing documents. Rules are, their own set of restrictions, right? So under Florida law, there is a test for determining whether a rule is enforceable. Okay, and I'll just briefly mention them. But when you send a violation over to your legal counsel based on enforceability of a rule, the first thing that your legal counsel is going to do, hopefully, is evaluate whether this rule is even something that can be enforced. So the first test really to determine if the rule is enforceable is you have to have authority in your governing documents to adopt the rule you're trying to enforce. Okay, so typically your declaration or your bylaws will give the board authority to adopt rules. So make sure you have that authority in your governing documents. The second test for a rule to be enforceable is that the rule cannot conflict with an express or an implied provision in your declaration. So for example, if you have a declaration that doesn't address pets, doesn't prohibit pets, and then you go ahead and adopt a rule that prohibit pets, well, under the law, that rule now conflicts with a silent provision in the declaration. Because the declaration is silent, the presumption is that there is no restriction against pets. Okay, so if you go before a judge to try to enforce that pet rule, the judge will not likely enforce it, and the association will lose. And then the third prong really is that the rule has to be reasonable. That is a subjective standard, so ultimately it's really up to a judge to decide if the rule is reasonable. Okay, all you can do as a board is adopt a rule that is in the best interest of the community and that you find reasonable. Okay, so assuming your rules and restrictions are clear and can be enforced, you want to make sure that when you enforce violations, you do it in a uniform manner. You don't just arbitrarily or selectively enforce them. You want to enforce them against all violators. That means, if Sally has a fence violation and, Jimmy down the road has a similar fence violation, that you uniformly enforce that violation against both of them. and not just against one of them. Okay, if you, selectively enforce violations against one owner and not another, then you open yourself up to successful defense of selective enforcement. And it'll come in the manner of what I've just described. Sally has a fence violation, you didn't enforce it against Sally, then Jeff comes around and he has the same fence violation. You send a demand letter to Jeff to correct the fence violation. Well, now Jeff can say, well, you haven't enforced Sally's violation, and now you are selectively enforcing the restriction against me. And if properly raised, that would be a successful defense to your enforcement action. All right, and third, you want to make sure that you enforce all your violations in a timely manner. So what that means is that, under Florida law, you need to have commence your enforcement action, which typically is a legal action in court, within 1 year from the date that the board knew or should have known of the violation. So, for example, going back to this fence violation, right? If the violation is out in the open, okay, then the law presumes that the board should have known of the violation. Okay, so you have 1 year from the date of knowing or the date that you should have known of the violation to enforce it. If you don't do it, okay, if you don't timely enforce the violation, then again, you subject the association to a potential defense of waiver. Okay, when you bring that legal action against the owner on that fence violation, now that owner can say, well, board, you've known of this violation this whole time, you've failed to take timely action, and now you have waived the ability to enforce it against me. Okay, and waiver is a defense that the law recognizes. Okay, so again, you want to make sure your covenants and restrictions are clear and expressly set forth in your documents or rules. You want to make sure that you enforce all your covenants and rules in a uniform fashion and timely. Okay, those are at least the minimum elements that you need in order to successfully enforce a violation. Now, directors owe a fiduciary duty to do what they reasonably believe to be in the best interest of the association. So the board has a fiduciary obligation to enforce covenant and rule violations. And if you don't, then you potentially subject the board to claims of breach of fiduciary duty. Okay, so this is where if you want to check with your insurance agent to make sure that you have D&O coverage, which is directors and officers insurance coverage, which protects board members from these potential claims. All right, moving on. So some specific covenants and restrictions that the board, will likely have to enforce include, and I've identified some here, architectural standards or alterations to the parcels. So if owners want to, replace their exterior doors or shutters, and you have, specifications of the type of exterior alterations that an owner can do, okay, and an owner installs, let's say, a purple door, whereas your specification says only, black doors can be installed, then that would be a covenant that you will want to enforce. Age restriction, especially if you're in a community that's considered as housing for older persons. Pet restrictions, restrictions on leasing or sales, restrictions concerning guests or occupancy, certainly parking and vehicle restrictions, and lastly, nuisance conduct. These are, the more typical covenant and rule violations that you would be enforcing. The important thing to take away here is that with all these covenant and rule violations, and you might have other restrictions in your documents specific to your community, but to successfully enforce any of these violations, you want to make sure that you document the violation. Okay, document, document, document. When you bring this violation to your legal counsel to start enforcement action, typically, at that point, you're already looking into court proceedings. Your attorney will ask for evidence, documentation confirming any of these violations. And if you don't, then most likely, legal counsel will advise you not to start formal legal action in court because otherwise you will lose. Judges will require proper documentation, and proper documentation can come in many forms. For example, complaints. For example, if we're talking about nuisance violation and residents complain to the association about an owner's nuisance conduct, you want to file those. You want to keep those written complaints or encourage owners to submit their complaints in writing. Documentation can come in the form of, internal reports. If you have a security guard, or you have, concierge in your building, and they're contacted about a violation in the middle of the night. Typically, these security teams have to document the incident in a report. Those internal reports can be part of your backup to support the violations. They can come in a form of violation notices that you or management have sent to the violating residents, witness statements, photographs, videos, even police reports. There are instances where residents might call the police on a violation of an owner violating, typically in a nuisance situation. Those police reports, file them. They all become part of your backup file that you will ultimately need to turn over to your legal counsel to commence formal legal action. Okay. I also want to just briefly mention with nuisance conduct. Those are typically the more difficult types of violations to formally enforce in court. Okay, so if the complaint is that this owner is just unreasonably loud at certain times of the day, or just conducts themselves in a form that I don't know, affects the peaceful enjoyment of the unit or parcel by someone else, it's not just enough to say, well, this guy is just a nuisance. Okay, you need to document every incident of violation. So every time that owner is loud, make sure it's documented, because the more documentation backup we can provide, the more likelihood you'll have in succeeding in abating that violation. Okay. All right, so enforcement action. Typically, the first step is to send an owner a violation notice. Okay, so if the violator is the owner, you'll mail the letter, ideally certified mail and regular mail, to the owner. If the violator is a tenant or an occupant, then you'll want to send the violation notice to the tenant occupant as well as the owner. Remember, the owner of the unit or the parcel is ultimately responsible for the conduct of the tenant or any other occupant of the unit or parcel. So it is up to the owner to ultimately make sure that the violation gets corrected. So you'll want to make sure that you notify the owner of the violation as well. The violation notice, doesn't have to be a complicated letter. You'll want to definitely state what the violation is, what the individual needs to do to correct the violation, and then provide a reasonable opportunity for the individual to correct the violation. Now check, do you have a violation policy in place? If not, you might want to consider, adopting a violation policy. You might have a policy where, for example, management or the association sends, the first notice of violation, an initial notice of violation, and then it might be followed by a second and maybe even a third and final violation notice before you refer the violation over to your legal counsel. There's no right or wrong as to what violation policy you want to have in place. Maybe you just want to send a first and a final. Okay, but whatever policy you have or you end up adopting, make sure that you uniformly follow that violation policy for all violators. Okay, so if you sent Sally a first, second, and a final notice on offense violation, you want to make sure that you send the same amount of notices to Jimmy on the same violation. All right, to avoid owners claiming or raising defenses to challenge the enforcement action. And as I mentioned earlier, you want to make sure that you collect all these violation notices and then all this backup documentation of particular violation to then refer the matter to your legal counsel. And typically a legal counsel will send a, I guess, a final demand letter to the violator before pursuing further legal action. And more often than not, the letter on the firm's letterhead will, encourage compliance. Not all the time. All right, and if the violator still hasn't complied with your violation notice, then now you're looking to enforcement options. All right, so one form of enforcement is fining. We'll talk briefly the process for fining with HOAs, although it is substantially a similar process for condominiums. So with HOAs, the association has the authority, the ability to fine owners and their tenants and guests for failure to comply with the governing documents and association rules. You don't need to have the authority for fining specifically set forth in your governing documents. Okay, the statute already gives you that authority. Now, the statute says that the fine cannot exceed $100 per violation, okay, and it can be levied for every day that violation continues up to a maximum of $1,000. So let's take the violation of a commercial truck or commercial vehicle. Let's say you have a restriction that says no commercial vehicles can be parked in condominium property. This owner brings in a commercial vehicle. All right, you've already sent the owner a violation notice saying he has to remove the commercial vehicle. The commercial vehicle remains there. So for each day that vehicle remains there, okay, you can fine the owner up to $100 per day, up to a maximum of $1,000. Now for HOAs, the statute specifically says that a fine of less than $1,000 cannot become a lien. Okay, so what that means is that a fine of $1,000 or more can become a lien, provided your governing documents give you that authority to adopt fines of more than $1,000 and the authority to then collect that fine as a special assessment against the owner and then ultimately lien the unit or parcel for that fine, and then if necessary collect it through collection foreclosure proceedings. Okay, some of the older documents typically will not have that authority. This is something that you'll have to most likely amend your declaration to give you the specific authority to adopt fines of more than $1,000 and then to lien for fines of more than $1,000. So, get together with your legal counsel about, drafting appropriate language to give you that authority. Now, the fining process for HOAs and really condominiums as well is a two-step process. I'm not going to go through the specifics, but remember that first the board must adopt the fine at a duly noticed board meeting. Just post notice of that board meeting 48 hours in advance. But that fine cannot be imposed until the fining committee or your grievance committee, however you want to call that committee, ultimately conducts a hearing, okay, and either ratifies or rejects that fine, okay? So the second step is to have that committee meet, have a hearing, and you need to provide the violator notice of that committee hearing 14 days in advance. Now, only if the committee affirms the fine can the fine be imposed. Now, the committee has to be comprised of at least 3 members, has to be appointed by the board, and those committee members cannot be officers, directors, or employees of the association, or the spouse, parent, child, or sibling of the officer, director, or employee. If the committee ultimately confirms the fine, then the fine is due within 5 days after you've notified the owner of the fine imposition. So for condominiums, again, it's substantially similar fining process, the two-step process with the board first adopting the fine and the committee then ratifying the fine. Again, you don't need to have authority in your governing documents to specifically fine. Condominium Act already gives you the authority. The only difference really is that with condominiums, a fine cannot become a lien. Okay, and it's regardless of what your governing documents say, a fine for condominiums cannot be collected as a lien. Now, if the owner doesn't pay the fine, okay, now you have a delinquency on a monetary obligation owed to the association, and that can be used by both condominium and HOAs as a basis to also suspend use rights to common facilities. So we'll talk about suspension of use rights and voting rights. So this applies to both condominium and homeowner associations have the ability to suspend rights of an owner or tenant or an occupant to use common facilities if they're more than 90 days delinquent on a monetary obligation owed to the association. Monetary obligation can include fines, assessments, interest, attorney's fees. Okay. In order to impose or adopt a suspension, this one is a much simpler process. If you're suspending use rights because of delinquency, then you don't need a committee hearing. This is something that the board can do at a duly noticed board meeting with notice posted 48 hours in advance. So for this type of suspension, you do not need a committee hearing. Now, the suspension applies to common facilities, which typically would include your pool, your gym, your clubhouse, your recreation room. It would not apply to common areas or elements used to provide access to the parcel or utility services. So you cannot suspend utilities if an owner is delinquent more than 90 days. You cannot suspend their ability to park or their vehicular or pedestrian ingress, egress to the parcel. So you can't prevent them from going through the gate and be able to park. For condominiums, you also won't be able to suspend the rights to elevators. Okay, or for example, to limited common elements intended to be used only by that unit. So you wouldn't be able to suspend the owner's use of his or her balcony or any other limited common element. Okay, or common elements needed to access the unit. So you can't suspend an owner's right to use the hallway, for example. Okay, this only applies to your common facilities. Now, only distinction here is for condominiums. For condominiums to suspend voting rights, not only does the owner have to be delinquent on a monetary obligation to the association for more than 90 days, but the monetary obligation has to be more than $1,000 and more, and you must notify the owner of this delinquency at least 30 days before you proceed to suspend the owner's voting rights. Okay. To take effect, you'll have to send written notice of the suspension after the board has adopted to the unit owner. And then if you end up suspending voting rights, okay, then the voting interest that's allocated to the unit or the parcel will not be counted towards the votes that you need on an action that requires membership approval. So for example, many associations use this as a tool to reduce the voting percentage that you need to approve an action. So for example, if you are contemplating amendments to your governing documents, and these amendments might be controversial, okay? And let's say you live in a community with 100 units or 100 parcels. Well, if let's say you have 10 owners who have been delinquent or more than 90 days delinquent, okay, and you properly suspend their voting rights, okay, then now instead of 100, okay, now you have 90 units or parcels, okay, that will be counted towards the vote you need. So if you need now a vote of a majority of the unit owners or parcel owners, okay, majority now is 50% plus one of 90, not 50% plus one of 100. Okay, and the same thing for quorum. Quorum would then be calculated based on the 90, not the 100 owners. Okay, so that's how suspension of voting rights could be useful. Okay, you also have the ability to suspend use rights for covenant and rule violations. So you can fine for covenant and rule violations. You can also suspend use rights for covenant and rule violations for a reasonable period. And again, this only applies to common facilities, the gym, the pool, the clubhouse. If you suspend use rights for covenant and rule violations, okay, you need the two-step process. This is one where, again, and this is for both condominium and HOAs, this is one where the board must first adopt the suspension at a duly noticed board meeting with 48-hour advance notice. And then the committee, the grievance committee, has to confirm that suspension with 14-day notice provided to the violator of the committee hearing date. Okay. Now, just one other point, suspension of use rights, it would be a good enforcement tool if you have the ability to control access to these common facilities. So if you can deactivate the fob, then yes, this would be a useful enforcement tool. Otherwise, it might not be an enforcement tool. So another option is to go through the dispute resolution. Okay, this would be the dispute resolution process before you file formal legal action in court. So if suspension of use rights is not useful to you, or fining is not useful to you, or you've tried it and it doesn't work, then legal action is probably what you will need to institute here to address the violation. Now, for HOAs, before you can file a lawsuit against the owner to force the owner to either to address the violation, you have to go through a pre-suit mediation process. Okay. Now, the statute defines what disputes are subject to mediation and what disputes are not. Disputes that are subject to mediation include use of or changes to the parcel. For example, if an owner undertakes an unauthorized alteration, that would be a dispute that's subject to pre-suit mediation before you can file a lawsuit against the owner. Amendments, meetings of the board, committee meetings appointed by the board, membership meetings, access to official records, and covenant enforcement. Okay, so all covenant enforcements are subject to pre-suit mediation, and we'll talk about momentarily what that process is. There are certain disputes that are not subject to pre-suit mediation. They include collection of an assessment, fine, or other financial obligation. So if an owner is delinquent, okay, and you want to go ahead and lien and foreclose, you don't have to go through the pre-suit mediation process. You proceed with the collections process that's set forth in the statute. Any action to enforce a prior mediation settlement agreement between two parties is not subject to pre-suit mediation. Eviction or removal of tenants or occupants, that's an important one. We typically get a lot of violations involving, tenants violating covenants or occupants, and the board wants to compel the removal of these individuals from the units. Okay, so under the statute, we can proceed to file a lawsuit in court, okay, to either evict the tenant if you have authority in your governing documents to do that. Otherwise, the lawsuit would be in the form of an action filed against the owner to force the owner to remove the occupant who's violating or unauthorized. Okay, so it makes the process go a little bit quicker. Alleged breaches of fiduciary duty by one or more directors. So if an owner is to file a lawsuit against a board member for breach of fiduciary duty, they don't have to go through pre-suit mediation. Recall and election disputes, as well as disputes and between and among person owners that do not involve the association. All right, for condominiums. It used to be that for condominiums, you had to go through a pre-suit arbitration process before you can file an action in court. Okay, the statute was changed several years ago, so now the association can elect whether to go through non-binding pre-suit arbitration or through mediation. Okay, so the condominium statute also defines the types of disputes that are subject to pre-suit mediation and arbitration. So, for example, the authority of the board under the law or the governing documents to require an owner to take an action or refrain from taking an action. So that involves basically covenant enforcement, covenant and rule enforcement. Okay, so all covenant or rule violations are subject to pre-suit mediation or pre-suit arbitration for condominiums. If the dispute has to do with an alteration to the common elements, that's subject to pre-suit mediation, as well as the failure of the board to properly conduct elections, give adequate notice of meetings, properly conduct a meeting, or allow inspection of records. So if before an owner files a lawsuit against the association on any of these issues, they have to first choose to mediate or arbitrate the dispute. Condominium disputes that are not subject to pre-suit mediation or arbitration involve title to a unit. This typically comes up when an owner acquires title to a unit without going through the application process. So the owner is technically unauthorized and the board is considering disapproving the owner. Well, one way of basically getting the owner out of the unit is to void title. Okay, so we would not have to mediate or arbitrate that dispute. We can just go to court to address this issue. Collection of assessments, not subject to pre-suit mediation. Again, eviction or removal of tenants or occupants, just like with HOAs, not subject to pre-suit mediation. Alleged breaches of fiduciary duty, as well as claims for damages to the unit based upon alleged failure of the association to maintain the common elements of condominium property. So, for example, if an owner claims that their unit was damaged because of the failure of the association to maintain a common element, pipe, let's say, the owner can file a lawsuit against the association without having to arbitrate or mediate. For condominiums, also just know that recall and election disputes are not subject to pre-suit mediation. They have to be arbitrated. And then disputes between and among owners and tenants, unless the association is a party, okay, to the dispute, they're not subject to pre-suit mediation or arbitration. So what does that procedure look like? Okay, so I've generically just kind of outlined very briefly here what that process is. If you're a homeowner association, this is the process you follow. If you're a condominium and the board elects to do pre-suit mediation as opposed to arbitration, then you have to follow the statutory procedure set forth under 720, Chapter 720. So typically that involves sending the violator a letter. Okay, you have to identify at least 5 mediators. Okay, and then the violator, the respondent in this case, has 20 days to respond to the certified mail agreeing to mediate. Okay, now presuming that the violator has agreed to mediate, now you have 90 days. You select a mediator, and now you have 90 days to mediate. Both parties share the mediation fee equally. Okay, there's no prevailing party fees in mediation. Every party is responsible for their own attorney's fees and to share the mediation fee. Now, if the violator, the respondent, did not timely respond to your letter for mediation, then what's going to happen is that the respondent, if there's eventually a lawsuit arising out of this claim or this violation, even if the respondent prevails, they would not be entitled to recover their attorney's fees in that lawsuit. Okay? And if there's either an impasse at mediation or if the violator just did not respond to the letter, then the association can proceed in filing a lawsuit against the violator to enforce the violation. Okay, and the prevailing party would be entitled to prevailing party fees. So this is, remember when at the beginning of the webinar, I said, make sure that you document all your violations, okay? Because if you end up going through the mediation process, or let's say the violator doesn't respond to your mediation letter and you end up filing a lawsuit in court against the violator and you don't have proper backup, you could lose. And the consequence of losing is that the owner would then be entitled to prevailing party fees. So we get this all the time where the board is just very eager to enforce a violation. But then when we ask, well, where's your backup? Or if we say there's not enough backup, they don't understand why we can't proceed in court. Well, you will just subject the association to potentially losing and then having to pay the owner's fees. All right. So make sure you back up every violation. All right, and then I've also outlined the pre-suit arbitration proceedings for condominiums. So again, with condominiums, the association can choose to either go through pre-suit arbitration process, which is non-binding arbitration, or you can elect to go through pre-suit mediation. If you select pre-suit mediation, you have to file the statutory process that's set forth in 720 that I've just outlined. Otherwise, this would be the process for filing a pre-suit arbitration. I will tell you that at least our firm, we prefer to mediate as opposed to arbitrate disputes. Arbitration is, unlike mediation where you have a mediator, a third party that sits with both parties to try to resolve a dispute. Arbitration, you have an arbitrator which acts as a judge, and you have a mini hearing, like a mini trial, and then the arbitrator decides how to resolve the dispute. And we have found in our experience that some of the decisions made by arbitrators are just arbitrary. Okay, make no sense. So essentially, you will file a petition with the division. You pay a filing fee, which is still set at $50. An arbitrator is appointed to your case. The arbitrator will confirm jurisdiction. And assuming there's jurisdiction to proceed, then the arbitrator will send the petition to the respondent for a response. Okay, typically there is a hearing, and then the arbitrator will ultimately issue a final order. The prevailing party in that arbitration is entitled to recover prevailing party fees. Okay. All right. And I think that is it. I'll certainly stick around. I'm sure many of you have questions. So I'll stick
Thank you.
around. I don't know if you want to enable the chat, Jeff.
Yeah, I enabled the Q&A, folks. What I'm going to mention too is that while we want you to hang around, listen to some of the questions and the answers, the required part is over. So I placed the link into the chat area. You can click on that link. And before Kerstin gets to the few questions that are in there now, excuse me, you click on that link into the chat, it'll open up this evaluation page. And again, I'll go over this once more when we get done with the Q&A. You fill this evaluation out, hit that submit button. After you hit that submit button, you will get a new tab that opens up in your browser with this boxed area. This serves as your attendance certificate. We will upload your credits if you're a manager. We just verify you were here for the entire required portion, and we'll take care of uploading them. But if you wish to save a certificate, this is how you do it. Underneath this boxed area, it says click here to print your certificate. Click on that. Your printer dialog box will open up. You can choose your printer or save it as a PDF or take a picture of it with your smartphone. And also within the boxed area, it says click here for the slides. Click on that. Another tab will open up with the slides. You can then save them or print them. I recommend saving them versus printing them because this will use up a lot of your ink and toner. I'll go over that once more a little bit later. Kerstin, do you have the Q&A open, or would you like me to dictate them?
Let's see. I got it. Some very good questions here.
And folks, before she gets started, I just want to mention there's about 15 minutes left in the advertised time. We'll get to as many as we can if they are on topic, and as long as they're not too specific to your association. Okay. So if we don't get to your question, those are the reasons why we would not get to them. So back to you.
Okay. Excuse me. Let's see. I have a question here from Brad. Does the board vote to adopt a violation policy, or do you need an owner vote? We have nothing in our documents. So a violation policy is not something you would necessarily see in your governing documents, perhaps maybe in the bylaws. You know, sometimes you might have just very generic wording, but you know, typically a board is the one that adopts rules and policies. Okay. I have seen instances where membership approval is required. So you'd want to check your bylaws to see if there is specific, number one, that you have authority to adopt rules and policies. And number two, that it is a board vote that you need and not a membership vote. Okay. So check your bylaws. Let's see here. Jeez.
I was on mute while Kerstin's looking for the next question. Monique, I see, would we be able to get a copy of the presentation? I went over that a little while ago, and I'll do that again at the end about how you get the slides, and as well as viewing this when it's over.
So Clyde, once a fine has been paid and corrected, can that same violation and fine be imposed several times? I mean, certainly, if you have a violation of, let's say commercial vehicle, right? And you start fining the owner, and then the owner ultimately corrects it and removes the commercial vehicle from the property. Okay, the violation has been corrected. If, a month down the road, that owner brings that commercial vehicle back to the property, he's in violation, and you start the whole process again. Okay. If a condominium board, this is questions from Kathy, if a condominium board has allowed a violation to exist for more than 20 years, what is their statute of limitations to decide to follow violation procedure? So remember I mentioned that violations have to be enforced in a timely fashion. And that typically means 1 year within the date that the board knew or should have known of the violation. Okay, so if you have a violation that's been there for 20 years and you try to enforce it through legal action, then yeah, you subject the the enforcement action to potential claim of waiver. Okay, so if the owner properly raises that defense, you can lose and you would be entitled to prevailing party attorney's fees. Now, depending on what the violation is, there is a process by which the board can resurrect, for lack of a better term, a covenant or rule that has been waived. Okay, it's called republication. All right, and it is a board action. It's something that the board can do at a board meeting. Let's say, going back to this vehicle restriction, let's say the board hasn't uniformly enforced vehicle restrictions for years, and now you've got 10 owners with 10 commercial vehicles parking. Okay, well, at this point, you probably have waived the ability to go back and enforce the violation and require all the owners to remove the vehicles. So the second best option would probably be to republish that vehicle restriction, where you basically tell the owners that you've not enforced this restriction in the past. Now you're going to do it going forward as of, January 1st. Okay. But the caveat with that is that you have to grandfather in existing violations. So those 10 owners that have had their vehicles, commercial vehicles parked at the condominium, they will be allowed to keep the vehicles. But as of January 1st, okay, any new owner that comes in with a vehicle, now you're going to be in a position to enforce the violation without this waiver defense sort of hanging in the background. Okay. So, get with your legal counsel about, the process of republication. We've certainly assisted, hundreds of clients with that process. So yeah, that would be a way to address that. Let's see. Jill, what if we have no committees? Can we legally fine? Well, if you have no committees, then yeah, you're in a pickle, because the statute makes it states very clearly that it is a committee that has to not fine, but ratify the fine. So remember, with fining, the board adopts the fine, but then once you adopt the fine, you have to give the owner an opportunity to go before a fining committee, okay, for a hearing, to have the owner, present evidence, dispute the fine, whatever. And then the committee is the one that says yes or no. If the committee ratifies the fine, then the fine can be imposed. If the committee rejects the fine, then the fine cannot be imposed. But you do need the committee to be able to go through that final step.
Inevitably, this question always comes up. Can board members be on the fining committee?
So no board members, no directors, no officers, no employees, unit owners that are not on the board. Okay. Let's see. Okay, so interesting question from Dan. Would an unpaid violation fee or interest or unpaid HOA eliminate eligibility to nominate themselves for the board of directors, even if it's only for $1? All right, well, there is a distinction here. So for condominiums, okay, the statute was amended some time ago to say that only if you are delinquent on assessments, okay, would that preclude you from having your name put on the ballot, okay, for election. It used to be that if you're delinquent on any monetary obligation, which would include unpaid fines, that would disqualify you. But now, to be clear, for condominiums, only if the individual is delinquent on assessments, okay, would that preclude the individual from being placed on the ballot for election. For HOAs, yes. If the owner is if the owner is delinquent on any monetary obligation, which would include fines, okay, then yes, yeah. That would preclude the owner to run for the board.
Thank you, Yolanda. It's much appreciated when we hear comments like that. Very great, informative session.
Thanks, Yolanda. So Dennis, Question from Dennis. If you fine an owner $1,000 after 10 days for the wrong collar door, does the owner get to keep the wrong collar door? Is it per year or lifetime? So it's per violation. Okay, so if the owner painted the door, purple, you've told the owner to remove the door or change the color, whatever, hasn't done it. You've gone through the fining process up to a maximum of $1,000. The owner hasn't paid the fine. Well, the violation still exists. So the violation still needs to be corrected despite of the fine, right? So if fining didn't work, then you have to either contemplate, suspension of use rights or proceeding with more formal legal action, which would be pre-suit mediation before you file a lawsuit. Okay. For HOAs, unless you have the authority to then collect a fine of $1,000 or more through the lien foreclosure process, then the fine will just stay on the account. And the same thing for condominiums. You can't lien for the fine, so the fine will just stay on the account. And hopefully, if the unit or the parcel gets sold, you can collect it hopefully at that time. Okay, but you still need to enforce the violation. All right, let's see what else. So Monique asked a question, if the HOA documents do not specify a time frame for issuing violations, is it advisable to adhere to the statutory time frame? So there's really no statutory time frame within which you have to notify owners of a violation. Okay, so this is where you want to adopt a policy. And not all violations are going to be the same. You might have a vehicle violation, you might have a maintenance violation. So for some violations, you might want to give 30 days. For other violations, you might want to give less time to correct. Okay, so you want to give the board, when you adopt the policy, some discretion of, the board gets to determine how much, reasonable notice, but how much notice to give to the owner to correct the violation. Let's see. Our covenant committee, question from Sean. Our covenant committee will recommend fining on a first offense, for example, regarding work being done inside their condo without a permit from the administration office. Do you feel this is appropriate? Well, I mean, I think that's a business decision of the board, right? I mean, many boards feel that fining is just not a useful tool for them, right? Ultimately, the fine is not paid and it just kind of sits there and it doesn't really address the violation. So you might not necessarily want to have fining as your, first form of enforcement. That's purely business decision.
Okay.
Let's see. Christopher Carter asked a very interesting question. Could you comment on the self-help remedy versus violation fining? All right, so self-help remedy, what Christopher is referring to is the ability of the association basically to, step in the shoes of the violating owner to correct the violation. Okay, well, first of all, and this is for both condos and HOAs, you need to have specific authority in your declaration for self-help remedy. So typically this will come in the form of maintenance violations, right? Let's say HOA, if an owner doesn't mow their lawn, there has to be specific language in the deck that says the association can then go onto the owner's lot to mow the lawn as a potential remedy. Okay. So assuming you have the authority, you need to be aware that there's been recent case law, okay, on self-help remedy. And what the case law says is that if you have self-help remedy in your documents, even if it's described as an option, not a must, but an option. So for example, if it says the board has the discretion, but not the obligation to go onto the lot to mow the lawn, okay? if you have language like that, then courts have said that now the association has to first exercise that self-help remedy before you file legal action in court to force the owner to undertake that, maintenance, to correct that maintenance violation. Okay, so self-help remedy is not necessarily recommended in all instances. You don't want the board or contractor to go onto a unit or a lot and then, have an altercation with the owner if the owner's there. There's potential liability exposure to the association, right? You could damage something, or, you expose yourself to frivolous claims of damage. So self-help is not necessarily recommended, but if you do have that authority in your documents, you now have to exercise it before you then file a lawsuit to force the owner to correct it. So check with your governing documents, and then, speak to your legal counsel about how to address self-help.
Let's pick
All right,
one, because we have 2 minutes before the advertised time. Then I'll go over the evaluation process and getting slides and documentation one more time. And folks, if your question doesn't get answered, again, we had so many folks on board today. We apologize, just not enough time for everything. But you can also place some of these questions into the evaluation that we mentioned in field number 10. And if you'd like to have Kerstin contact you about potentially working with your association, you could also mention it on the evaluation.
All right, so just quickly, John pose a question. If our board is not doing the fining, but leaving it to the fining committee to decide the fines and also ratify them, are the fines valid? So so under this procedure that you've described, the valid would likely not be valid. And if you end up trying to collect for it, and by collection I mean not through the lien process, but you can always file a small claims action to collect the fine. Most boards don't do that because it costs a lot of money to collect a fine of $1,000. But no, that would not be the proper fining process. Again, the board adopts the fine first, and then the committee has to ratify the fine with a 14-day notice of the hearing. Okay, I think that's it, right, Jeff?
Yes.
We're out of time.
Great job there.
All right. Thank you so much, everyone, for listening and for your questions. These are very good questions.
Kerstin, yeah, I know you've got to get running and tend to some client stuff. If you need to contact Kerstin or are interested in working with Kerstin and K. Bender-Renbaum, you could reach Kerstin at khenze@kbrlegal.com. Her name and email is on the screen. You'll also receive a follow-up email tomorrow, everybody who attended, with contact information as well as the same evaluation link, which I will go over again in just a second. So Kerstin, any parting words before you head out and I take over with the evaluation process?
Just thank you again for attending, and hopefully we got you to your lunch.